Good evening, I'm Dan Wall.
And I'm Laura Lee. Thanks for joining us. In the final installment of our three-part series looking into the Minnesota sex offender program, we look at how effective it really is.
The controversial program was ruled constitutional by an appeals court in 2016. Since then, the Department of Human Services says more people are being released.
But a legal expert we spoke with says that $112 million used to fund this program can be better spent elsewhere to help prevent sexual violence.
We've learned what it means to be a healthier individual and the healthiest versions of ourselves. And we need the opportunity to reintegrate back into society.
Russell Hatton has been inside the Minnesota sex offender program for 16 years. He and Dan Wilson agreed to sit down with us. They claim they have participated in treatment but are not moving through the three-phase program and fear they never will.
I have a sex offense conviction on my record. I went to prison for that for 4 years. That may not have been long enough. Maybe I deserve longer. Then we need to lengthen the criminal sentencing for sex offenders. But to masquerade a prison as a treatment center is the wrong way to do it. It's intellectually dishonest.
The Minnesota sex offender program is a treatment center for mentally ill and sexually dangerous people operated by the Department of Human Services. These are individuals who have already completed their prison terms. Some have no criminal convictions, according to DHS. But rather than placing them under supervised release, counties file petitions to civilly commit them inside MSOP for an indeterminate amount of time.
We know that sex offenders come out of the Department of Corrections all the time. So how does the county attorney decide which ones go into MSOP and which ones get reintegrated back into society under supervised release?
Sure. Under the law, we have to prove that they're a sexually dangerous person. And to prove that, we have to prove, one, that they've engaged in a course of harmful sexual conduct, two, that they have a personality disorder, a sexual disorder, or some other mental disorder or dysfunction, and three, that they're likely to re-engage in that type of harmful sexual conduct.
Kim Mackey is a St. Louis County attorney. Her office has petitioned about 20 cases over the lifespan of the MSOP program. Unlike criminal court, in civil court, these cases are not heard in front of a jury. Rather, it's a judge. But Mackey, who has been practicing law for more than 20 years, says the state still must meet the burden of proof to move a case forward.
One of my utmost concerns is community safety. And when I look at the people who have been committed and those who we seek to commit to the MSOP program, I look at, do we believe as a collective office that this person poses a significant danger to the community? And if so, we need to take some sort of action to protect the community.
According to a study by Williams Institute, the UCLA School of Law, more than 6,300 sex offenders are detained in civil commitment programs across the country. Of the 20 states highlighted in red with civil commitment programs, Minnesota has the highest number per capita of civilly committed sex offenders of any state. Only 21 people have been released in nearly 30 years.
In its time, if the theory is that we're moving people through treatment, we should be seeing those results, but we're not.
You know, some people may say, well, that's because of the particular people who are there. And, you know, and actually this is the program doing its job, keeping them out of the community. But in reality, Minnesota is an outlier.
Eric Janis is president and dean emeritus of the Mitchell-Hamlin School of Law. He has more than 2 decades of legal and scholar experience with a focus on sexual violence prevention. He is currently the director of Sex Litigation and Policy Resource Center. He says even if we accept the premise of what MSOP is, he says Minnesota is operating the program poorly.
Under our American system, if they're convicted of a crime, then they can be sentenced to a sentence that's authorized by law. And that's totally appropriate. That's accountability, retribution, and that's appropriate. No problem with that. Once they have fulfilled that sentence, though, our American Constitution says they cannot be punished anymore. That's called double jeopardy.
More expert witnesses are expected to testify in the coming days and weeks.
Janis was one of nearly 24 people, including judges and lawmakers, selected to be part of the Sex Offender Civil Commitment Task Force in 2013. They were ordered to examine the program when a federal judge ruled it unconstitutional after a class action lawsuit was filed by the clients inside.
One of the things that, if I recall correctly, the task force said was, We need to have a comprehensive approach to sexual violence. What we have now is not a comprehensive approach. We have a single arrow in our quiver, if you will, and that's MSOP.
He says one key finding was too many clients were locked up for too long. However, according to Nancy Johnston, who runs the MSOP program, she says the release rate is based on the client's own effort. Currently, 92 clients are provisionally discharged, meaning they're in transition to less restrictive settings.
There's always room for discussion at the legislature for change in how the law is written, which defines the criteria for release.
DHS says a client can petition for release every 6 months. The current criteria for release must be approved by a special review board and a 3-judge panel. Mackey says it's not an easy process, nor should it be.
So you end up going through a 3-judge panel to be fully discharged. There's a question about whether or not it should be that rigorous on the front end. For someone to go into the program, should they have a 3-judge panel as well?
I believe that there are adequate protections in the law right now for people who are petitioned for commitment.
But Janice argues the way into MSOP should be just as rigorous, with a clear policy of standard to commit someone.
So we could start by clarifying what level of risk we think justifies taking away somebody's liberty like this.
He says the current statute is too vague and can leave room for county attorneys to have different standards of review. Something Johnston agrees with.
With 87 different counties and 87 different judges making those decisions, you end up with a wide range of folks.
Interesting.
Folks like Wilson and Hatton, who say they've served their sentences, but those sentences never meant life behind barbed wire.
We don't want to just shut the program down and let everybody go. We want the proper steps taken so people can receive the help who may be still struggling with things.
I mean, we have overwhelmed the courts with hundreds of lawsuits. And that's not just because we want to be difficult. We want to go home to our families.
The 2023 operating budget for MSOP is $112 million a year. Now, taxpayers spend nearly $175,000 a year to house each offender, each client inside MSOP. Well, that breaks down to about $479 a day for each client. Nancy Johnston, the executive director, says the $112 million budget primarily goes to pay salaries for administration and staff at MSOP. The rest is to maintain the security at the facilities and for programming. Professor Janice suggests that some of the $112 million be allocated to prevention programs, including halfway houses and victim support. If you missed any part of this 3-part series, you can find it by heading to our website at northernnewsnow.com and click on the Featured Reports tab.